We're ready for the last case on the docket, Holmes Regional Medical Center versus David Wirth and Renee Wirth. Whenever counsel is ready to proceed.
Thank you, Your Honor. Good morning, and I'm Charlie Wells here representing Holmes Medical in this proceeding. And as I know the court is aware, we are here on a petition for certiorari. And what we are asking the court to do is to quash a summary without explanation denial in the trial court of the denial of a motion to dismiss having to do with what we submit is a defect in the pre-suit affidavit that accompanied the notice of intent in this medical malpractice context. Now let me address first the matter of certiorari. And this court, the law of this court, as I have traced it back, really probably beginning in 1994, but certainly in Central Florida Regional Medical versus Hill, established that in a medical malpractice pre-suit context that certiorari was proper because if you didn't go ahead and address what was a claim defect in the pre-suit process, then and went ahead and had to go to final judgment, that would defeat the whole concept of pre-suit. Now I do call to the court's attention that that is apparent from my review, uniform across all districts. And there's a recent case out of the 2nd District having to do with a defective affidavit similar to this case in which the 2nd District dealt with it on certiorari. The Supreme Court has taken cert in a case called Okren versus Williams. In reading the jurisdictional brief in that case, I do call to your attention there was raised the issue there of a conflict between the Okren case on cert and a case called St. Mary's versus Bell out of the 4th District. And now that case the St. Mary's case was different, I submit, in that there was a question in St. Mary's that had to do with whether the child was even a patient at the hospital. And the court in St. Mary's said that factual issue could not be dealt with on certiorari. However, as I say, I do point that out, but the law of this district appears to me to be the Hill case, which was decided in 1998, and is a case which is in line with what I submit is a sensible reasoning that pre-suit has got to be addressed if there is a defect prior to going all the way through a trial, or the whole concept of pre-suit is defeated. Now, I think that the importance, I submit to you, the importance of this case is whether the courts are going to adhere to the pre-suit process of the statute, because the legislature has tightened the requirements of who can sign an affidavit and who is an expert in pre-suit. This court had the Apostolico case in which there was...
Mr. Walter, are you asserting the proposition that a nurse never can be qualified to render an opinion as to proximate cause?
No, I'm not asserting there's never an instance, because I think that probably the Apostolico case points out an instance in which there were, under those facts, perhaps they could, although the Apostolico case really is no longer binding law because of the change of the statute, and they made a differentiation, that panel of this court did, in whether you could be an expert pre-suit and an expert to testify. But I think that the reasoning that under some set of facts that a nurse could be an expert on that, there was a PIC line, and that nurse had in the affidavit a demonstrated expertise in that area. However, what my basic premise here is that on the facts of this case and what happened in this pre-suit, that we really destroy the pre-suit process if we do not require there to be an affidavit that meets the statutory requirements prior to the expiration of the statute of limitations. Now, Kukral at the Supreme Court said that you could have an affidavit that would be submitted after sending the notice of intent, although the statute specifically says it should accompany the notice of intent. But the Supreme Court said that as long as the affidavit was there prior to the expiration of the statute of limitations, that the access to courts theory balance would prevail. But here, that didn't, we submit, occur, because what happened here was that this event, that this claim...
I'm clear that the fourth affidavit was filed after the running of the statute of limitations. What about the third?
The third was filed, the statute of limitations...
After the third was also filed after? That's what I thought.
Yes, and the second. The only one that was filed before was the first. And because there was a situation in which they submitted their notice of intent with this affidavit that showed that this lady, and I don't disparage her, but that from 1999 through 2006 had managed this rehabilitation and employment operation, and that's what it listed that she did. And they submitted that in May of 2008. Now, the statute of limitations ran, by my calculation, on the 23rd of July of 2008. You get 2 years from the date of the instance, which was in November of 2005, and then you file for a statutory extension, and then you get additional extension. And at first, the affidavit didn't have a CV attached to it. Mr. Doyle wrote back to counsel and pointed that out and said, this is defective because, and then there is no CV attached. They didn't send a CV.
So you think the statute of limitations ran when?
I'm sorry?
When do you think the statute of limitations ran?
I think July 23rd of 2008.
The complaint was filed on August 25th.
The complaint was served. I think the complaint was actually filed on July the 10th. And the complaint was served on August the 21st. And then the first attempt to amend this affidavit was made on January the 6th of 2009, right the day before there was a hearing. And then there was Judge Holcomb found that to be inadequate, or at least that's what he announced. He didn't actually, he announced that and then gave them 10 days. There was an order later entered They submitted another affidavit on the 16th of January 2009. Then they rocked along until May of 2009. The original counsel withdrew. In came Mr. Linder, and another hearing was then set in January of 2010.
Let me ask you this.
And there was another affidavit filed.
The case that you filed as your with your third notice of filing supplemental authority is a case out of the 2nd District, and in that case, the panel of that court decided that an evidentiary hearing would be required to determine whether the doctor actually had the expertise necessary to render the opinion that was given in the pre-suit affidavit, as I read that case. Right. And I'm just curious as to how you think that evidentiary hearing procedure corresponds with your argument, because it appears to me that if it's permissible for a court to hold an evidentiary hearing on the issue and allow the proponent of the expert to put on additional testimony to show qualification to render the opinion, that would indicate that they could also file a later affidavit. I mean, whether they were qualified or not at the time, I mean, doesn't change. I guess the question is whether... does that make sense?
Your Honor, it does make sense, and I've thought about that question as to whether... I think the 2nd District really didn't give us any reasoning for their decision to send it back for an evidentiary hearing. They merely cited, in my recollection, into an earlier case in which they had done something like that. It seems to me that this is really a question of law as to this whole pre-suit process. I think that if you get it over into the evidentiary process, then you're defeating, once again, the whole idea that this is something that is to be done and evaluated on the pleadings. And this is a situation in which you've got a statutory requirement that there be this participation in as an active nurse, in this instance, what I would say was a hospital nursing, during the period from November of 2002 to November 2005, and that this is something that has to be confronted or needs to be confronted as a matter of law, and in this instance, the way that it should work, I submit, is on the basis of an evaluation of what is submitted prior to the expiration of the statute.
So to accept your position, really, we would have to conflict with the 2nd District. I think there are other cases that contemplate or hold that an evidentiary hearing is appropriate to determine the expert's qualification.
I don't know of a case in the pre-suit. That's the reason that 2nd District thing sort of surprised me. But I'm not sure that in this instance that you're really in conflict specifically, because what I sort of thought they kind of hit that a lick at the end rather than it being part of their decision in the Holden case. And I think they cited to a case called Oliverus before that.
But I mean, the rule of law that you think is appropriate is that the court is constrained to look only at affidavits that are filed before a statute of limitations is run. And that, to me, that would be inconsistent with the holding that a court can take additional live testimony, other evidence, later.
Very well could be. And I think that it seems to me that where we got into a situation in these plethora of cases that have come down since this procedure went into effect, into a circumstance in which we were saying, the appellate courts and Kukral really started that ball rolling by saying, you know, access to courts means that we're going to have a procedure that is not going to automatically shut people out. But there was a lasso put on that in Kukrola by the statute of limitations. This court recognized that in Yoakum. But the essence of it is that the balance between the access to courts problem and the fact that what the legislature has intended to do from the start, and they increased that by their 2003 amendment, was that the high cost of medical claims in the state can be substantially alleviated by requiring early determination of the merits of claims. And so there has to be, in order to carry out that mandate of the legislature, an enforcement of this procedure. And that's what we are asking the court to do in this instance.
Okay.
And I would like to save the rest of my time for rebuttal.
Very good. Thank you.
May it please the Court, my name is Barbara Egan with Egan Appellate Law in Orlando, and I represent the respondent here. And I want to address first an issue that came up in Justice Wells' argument regarding the statute of limitation. There is no finding in this record as to when the statute of limitations ran. We're here on a petition for writ of certiorari, and it would not be appropriate for us to start making, or the court to start making factual findings in this case as to when the statute of limitations did or did not run. And I'm not sure that's even important, as I'll get into. But I would like to preface my arguments here first by emphasizing some important points regarding the Medical Malpractice Act. As has been recognized
why wouldn't it be apparent from the face of the petition and the attachments as to when the cause of action would have accrued and the statute would have begun to run? We know it's a 2-year statute of limitation. Right. We know it's a 2-year statute of limitation, but even in the record of this case, in, I believe, the initial hearing proceeding, it was described by counsel as not being crystal clear as to when the statute would run and whether the statute of repose had kicked in under the circumstances of the case. And that was actually discussed. Would you agree that Yoakum and other cases, I believe that's the case from our jurisdiction, state that it's not appropriate to consider an affidavit that's filed after the statute of limitations has run? Yes, absolutely, Your Honor. What the cases say... Are you suggesting we need to send it back for a determination of when the statute ran for the court to determine what affidavits it can or can't consider? No, what the cases say, Your Honor, is that if you have not complied with the pre-suit requirements, that is proper good faith investigation, which is evidenced by an affidavit of a corroborating expert, you can't come back and do that after the statute of limitations has expired. What the issue is in this case is whether the affidavits that were submitted from the inception of this case adequately described the nurse's qualifications such that she fit within Chapter 766 requirements. I think that's very different, and I think Your Honor alluded to that earlier and hit the nail on the head. Whether she's qualified at the time does not change. And because everyone had questions, because it wasn't explained, the affidavits were very poorly drafted, and as the supplemental affidavits were submitted, it was clear that she did have similar experience in consulting and actual clinical practice as the nurses on which she was commenting.
This Act, Chapter 766, is not
Would it be
designed...
your position that a plaintiff couldn't come forward with a new theory of negligence in an affidavit after the statute of limitations, couldn't come forward with a different affiant with someone new who's... But they can't... But after the fact, you can clarify whether or not the person who gave the original opinion is qualified to render that opinion.
Absolutely, and let me explain that a little bit. The affidavit is not to give notice of what the trial's going to be about. That is, I mean, that's the notice provided by plaintiff. Basically, I've investigated, these incidents occurred, we believe that's negligence, and we believe the negligence caused...
Let me ask you this. If your theory is correct, then why wouldn't it be appropriate in this case to have an evidentiary hearing? Because it seems to me like you have a CV that suggests that this nurse was an administrator with really no clinical practice whatsoever, and then it seems like the affidavit's got sort of more and more artful in the way that experience was described in order to fit into the statute. I mean, so it seems like they're almost... If you consider all the affidavits and the CV, there really is a question in my mind as to what her experience was, as opposed to how what language she uses to describe it. I mean, if she just administered a rehabilitation service, then that certainly wouldn't qualify her to render an opinion about hospital nursing, I wouldn't think.
And let me try to break your question down.
Yeah, no, it's probably. Sorry.
Justice Pariente. Sorry, Judge. I'm sitting here going, oh my God. Would you repeat your question? No. I absolutely think it's appropriate to hold an evidentiary hearing if there's some question as to how the affidavit's written, whether the nurse really has the qualifications needed under subsection .202, subsection 203, subsection 102. I think that's absolutely appropriate. But the policy behind the pre-suit notice requirement also has to be balanced against very, very important constitutional, and this is because it's balanced against very, very important constitutional considerations involving a citizen's right to access to court. This act is not to give hospitals a free pass on malpractice. We have a case where even under the circumstances of this case, you and I, in many respects, would probably be qualified to say that a negligence incident occurred. So we know we've got, in all probability on this record, an actual case of medical negligence. And I think and we also have in this case a situation where the plaintiff complied with pre-suit investigation in that it's not a no lack of affidavit case. They complied, but there were questions and particularly given the statutory amendments, does this nurse actually consult, or is the nurse actually involved in clinical practice? And I think it became very clear, if you read the affidavits, that yes, indeed, she did, and she was not explaining what it is that she actually did in her role. But I think, and I think not only in this newer case, but in earlier cases, including the Paley case out of the 4th in 05, that's traditionally when you're dealing with, do they have the qualifications, not whether you've got an affidavit, do they have the qualifications, then it is appropriate for the court, and the court should look at further evidence because the court has to evaluate whether the actual good faith investigation has occurred. Now, did I miss part of your question? I'm not sure. But I think it is...
Would you agree that the first affidavit doesn't sufficiently detail her qualification, doesn't demonstrate that she's qualified to render an opinion as to negligence and causation, both?
I think I was with you when I looked at that first affidavit. I thought, well, this seems more like she's not involved in clinical practice or consultation, but I didn't know what the terms in that affidavit meant. I think I would have been like the trial judge. What is it that you actually do, so I can evaluate whether you have the qualifications, and I would agree with that.
You would agree that the first affidavit was legally insufficient?
I don't know that it was legally insufficient. That's rather a hard question to answer, and it's also an important question because, as this court knows, on these types of proceedings under certiorari, we have to just look at essential departure from essential requirements of law. She said in the affidavit that she met the qualifications for an expert under Florida statutes, but she didn't really explain how she met those qualifications. And then I believe, if I'm remembering the first affidavit correctly, she goes on to actually delineate different things involving the case. And as I said before, this affidavit is not to prove the case for the plaintiff. That's not its purpose. This affidavit is to corroborate the claims of the plaintiff, to show that there's reasonable basis to believe that there has been negligence and that negligence has caused injury. So maybe it's a mixed question of law. In fact, I don't know. I mean, it was very hard for me to separate these considerations out because much of it to me seems like a factual determination, not a legal determination. But I'm aware of the cases that have said whether they've complied, and compliance involves submitting the corroborating affidavit, is a question of law which is appropriate for certiorari. So I know it's a hard job. I mean, it would be a hard job to me if I was sitting on the court to break out what is this fact or law.
Wouldn't you agree that an affidavit that does not demonstrate the affiant's qualification to render an opinion at all on the issue would be legally insufficient?
If all of the evidence that was presented to the court, all of the affidavits?
I'm just saying, hypothetically, if I submitted an affidavit that said, I believe there was medical negligence and that negligence caused the following injury, and I don't say anything about who I am or what my qualifications are, isn't that legally insufficient in that it doesn't demonstrate my qualification to render the opinion that I've given?
Probably.
Okay.
Probably. I'm still grappling with that. You know, that's for this court. But I won't say yet. I think so, probably.
Is that a better question?
Yes.
Okay.
Thank you. But I think I think what occurred in this case was appropriate, and it is our position, and it's my opinion, our opinion, in looking at these affidavits, and that the nurse obviously had the qualifications necessary to opine in that she had.
Let me ask you this. Even if you consider all the affidavits, and even if you determine that she's had the clinical nursing experience or the consulting nursing experience to render an opinion on standard of care, how is a nurse qualified to render an opinion on causation, which to me seems like a question of medical diagnosis, not nursing diagnosis?
Well, you have to separate that out, and you have to go back and look at what I don't think there's any cases talking about this in the context of causation, but you have to go back and look at the cases that talk about what the expert's opinion must pertain to involving negligence, in that you're not proving the specific negligence, and you're not proving, I would say, the specific cause of that negligence. In other words, she has to corroborate that it appears that a reasonable basis exists to show that negligence, breach of the standard duty of care occurred, and that caused injury. And in this case, it appears from the record and from what the claimant is contending that there were numerous injuries that occurred, including a more lengthy stay in the hospital and a greater expense. So they were, could this nurse testify at trial as to the specific catastrophic neurological injuries to this patient? I would say no. But the nurse is just corroborating the injury element of this medical malpractice claim, and I think.
I think you're right that probably anybody could say that if you stop breathing, there's going to be injury, but
for 13 minutes.
Right. But I guess isn't causation more than that? Isn't it linking that cessation of breathing and whatever injury flows from that to the negligence that they found? And the question I have is whether a nurse can do that. In other words, a medical doctor might say it didn't matter how closely he was monitored, given the amount of medication he was given, he was going to code, and that was going to cause this problem. Even if they checked on him every minute, isn't.
Well,
so the question is she really qualified to say that this breach of standard of care that I found is what caused the injury that I observed? And I'm struggling with that.
I think a nurse would be absolutely qualified to testify that a lack of respiration and oxygen to the brain, and I think she actually did for 3 to 5, up to 13 minutes, would cause brain injury. I think that would be within the realm of a nurse's practice. It's set forth in the Nursing Practice Act, and in the realm of what we all are aware that nurses have to learn about biology, neurology, all of that, just as a physician does. And this is pretty clear. This is not a complex, he got some strange disease from this. This is a man that went without oxygen to his brain, and that would cause neurological damage, and I think a nurse would be absolutely qualified to testify on that. And if there's no further questions from the court, I would like to conclude by saying that I think it's very important that this court adhere to the principles that the facts of this case need to be construed in favor of the claimant. I think the claimant has shown through the submission of further evidence that the nurse is absolutely qualified under the statute, and that she has a clinical practice as part of her professional responsibilities, as well as a consultation practice. I also think that the statutes continue to provide the courts with some leeway, although I haven't seen it really explained under 766.102 sub 12. It specifically says this definition of medical expert, doesn't change the leeway for the trial court to decide based on other qualifications. This was a nurse under the circumstances of this case that obviously, and I go back to, I think we could almost comment in this case to corroborate that an incident occurred. And I would ask this court to deny the petition for writ of certiorari and send this case back to the trial court for further proceedings. Thank you very much.
On the matter of the injury, their position here and in the briefs was, we don't have to show anything except there were some additional medical costs. But the statute, and I keep coming back, we got to give this statute priority. What the corroborating pre-suit investigation by claimant under 766.203 is such negligence resulted in injury to the plaintiff. So there has to be a causal link between what they're claiming to be the negligence and the injury. that they're claiming. Now, what they're claiming in their notice of intent in this case was a brain injury and severe and permanent injury. That's what they said, and when they filed their notice of intent in this case. Now, a nurse, in answer to Judge Cohen's question, there are certain nursing diagnoses that a nurse could give, but a nurse cannot give a differential medical diagnosis. The statute on nursing doesn't permit that.
I guess the question is, does it take a differential medical diagnosis to conclude that if someone's left in a condition where it's not detected that they aren't breathing for 12 minutes, that's going to result in injury?
Well, no, that's going to, but to link the negligence, what they're claiming is that this was a narcotic reaction which should have been detected by the nurses. To link the reaction to narcotics to the neurologic injury that they're claiming, that requires a medical diagnosis. And that's our position on it. And that in an instance in which this nurse, looking back to this first affidavit, didn't indicate that there was any qualification that she had that was going to allow her to make that type of differential diagnosis, even if she made it. Now, what I submit is that we here, a case out of the second, which is similar to what we're dealing with here on an insufficient affidavit, was decided before that Holden case in September by a different panel of the second district, in which they quashed the case in pre-suit case. That's Hunt versus Hupman at 28 Southern 3rd, 989. And so I would submit that here we do have a situation in which it was obviously the first affidavit that was submitted was ineffective. Judge Holcomb held that the second one was ineffective, but by that time the barn door was closed, so our position is that here you've got a situation in which the enforcement of this statutory scheme requires there to be a recognition that within the period that was permissible to file this pre-suit, that their submissions were inadequate, and therefore the Judge Wong's order should be quashed with an order that the case be dismissed.
Okay.
Thank you very much.
Thank you both.
Thank you.
Have a good day. Court's in recess.